Welcome everyone to another Friday afternoon employment law question and answer session. I'm here live. My name is Samara Belitzky. I'm a lawyer at Samfiru Tumarkin. I'm a lawyer in Ottawa, so our firm, as many of you probably know, has offices throughout the country. We have one in Ottawa, which is where I work, as well as Toronto and Vancouver, and now we also have an office recently that opened in Alberta. So I'll be here for the next half an hour or so to answer your questions. So if you have any questions at all related to employment law, workplace issues, severance pay, harassment in the workplace, issues with respect to COVID, issues with respect to safety, maybe with respect to COVID or layoffs, anything at all, I'm here. Now's the time. Send in your questions and I'll be happy to answer them. If for whatever reason you don't want to send your question in, but you're watching and you do have a question, you can always contact us directly through our website. If you don't want to, post your question publicly during our session today, you can go to employmentlawyer.ca and all of our contact information is there. So you can contact myself or any of our other lawyers that way. If you do have a question that either you don't feel comfortable asking today, or if we get a lot of questions in, which sometimes is the case, we get so many questions that we don't have time to answer everybody, unfortunately. If that does happen, you can certainly contact us there. Employmentlawyer.ca, again, is the website to go to get in touch with us. You can also email us at help@employmentlawyer.ca, and that email goes directly to our team, and somebody will answer you that way. So again, if that does occur, where you don't get your question answered or you want to ask us privately, please feel free to contact us that way. As always, I have a few things that I've prepared to talk about today if we don't get questions throughout the whole half hour. So the last couple of sessions that I've done, I haven't been able to get to any of my list because we had so many questions coming in, and that's great. That's fantastic. That's why we do this. So send in your questions, any questions that you might have at all, please send them in. Don't be shy. Now is the time. Like I said, I have some things that we will talk about, questions that we get very commonly, especially related to COVID-19, but I'd much prefer to answer your questions that you might have out there. So send them in. Like I said before, don't be shy. Send them in now, and we'll get to them. So while we wait for some questions to start coming in, I'm actually going to get back to a list that I prepared many months ago with respect to some COVID-19 questions and just issues with respect to COVID-19 that we see a lot in the last little while. I wasn't able to get through any of this list, like I said, in the last couple of sessions. So if there aren't a lot of questions coming in today, I'm going to go through them because the odds are if you're watching, you have these questions, or maybe you know somebody who's going through this and has these questions as well. So they're really, what we call kind of COVID-19 workplace red flags, issues that come up or seem to be coming up over and over and over again throughout the pandemic, and things that people are not necessarily educated on. You might not know what your rights are when it comes to these things, and you might not know what your employer's obligations are when it comes to these things. So if that's the case, hopefully you can learn something from the items I'm going to go through, because these are things, like I said, that come up very, very often. So the first thing, and I mentioned this a couple weeks ago in the most recent live that I did, I touched on it briefly. I'm going to touch on it briefly again because it's very important, and I'm continuously getting people contacting us about this particular issue, which is an employer bringing you back from a temporary layoff and asking you to sign a new contract. Now, if that's the case, if you're on a temporary layoff and your employer wants you to come back to work, but they make it conditional upon you signing a new contract, that's not lawful. It's not that you can only get your job back and go back to work if you actually sign a new contract. You have every right not to sign it, and as I always recommend, get it reviewed by an employment lawyer before you sign. If you're in a situation, even if it's not being recalled back from a layoff, if you've been at work this whole time, but your employer is still asking you to sign a new contract, anytime you're presented with a new contract, get it reviewed by an employment lawyer, get in touch with us. We can review it for you and let you know exactly what it says and what the consequences will be if you sign it. because most of the time, if your employer wants you to sign a new contract, it's going to be in their favor and not yours as an employee. Employment contracts usually protect employers. And so most of the time you'll see language in there that will limit your rights, and usually it's your termination entitlements in the future. So that's very important to know, that you don't have to sign a contract to be recalled back to work. Now, we have a few questions coming in, so I'm going to get to the questions, and then I might be able to get back to my list after. So I have a question from Mario from Facebook, who says or asks, how or why would an employer challenge a medical certificate due to a medical condition? So that's an interesting question. It's very general, it's very ambiguous, so it's hard for me to answer in specifics because I don't have the context, I don't have the exact situation. And Mario, feel free to contact me offline. Go to employmentlawyer.ca so that you can give us the specifics and we can give you proper advice. But in general, usually employers would question a medical certificate if it's being authorized or signed by a treating physician, by a doctor. These are trained professionals, and if they provide a medical opinion, that's usually taken on its face, at face value. If an employer is questioning it, perhaps it's because there's a history of mistrust. Perhaps the employer doesn't trust the employee. Maybe there has been a history there of the employee not being truthful. It's very hard to say. Of course, I'm just speculating. Maybe they're just, an unreasonable employer and they're just questioning it for no reason. At the end of the day, the reason why isn't necessarily relevant, but you certainly want to make sure that if the employer is questioning your medical note or medical certificate, that you do get legal advice, because once you provide a medical note or certificate to your employer, they do have to comply with it. That's the law. They have an obligation to either accommodate you by holding your job while you're on unpaid medical leave, and then when you're returned to work, you go back to that same job. Or if you are able to work, but you do have accommodations that are required because of a medical condition, then they still have to accommodate you up to the point of undue hardship. So basically, to the extent possible, as long as it's actually possible for the accommodation to take place, they have to accommodate you once you provide that medical note. So either of those situations, the employer does have an obligation to accommodate the employee. Again, I don't know the exact particulars, Mario, of your situation or of the person's situation that you're asking about, so it's hard to comment in specifics, but in general, they would have to follow that medical note and that recommendation from the person's doctor. So I have another couple of questions here. I have Iona from Facebook who asks if an employer has an obligation to provide modified work. So kind of similar to what we were just discussing, if you have a medical condition that requires certain accommodations, there are restrictions in place, maybe it's modified duties where you can't do all the same duties that you were able to do when you were completely healthy, or maybe it's a restriction with respect to your hours. Maybe you are on leave, you're coming back to work, and it's gradual, so you're back to work part-time. Maybe it's 2 days a week, maybe it's every day but only half days. Whatever the case may be, it's really in the discretion of your treating physician, of your doctor. And if that's the case, and your doctor is, in other words, prescribing that, you'd have to provide a medical note to your employer. And then they do, absolutely, Iona, have an obligation to provide modified work if that's what your doctor is recommending, and that's the doctor's note that you've provided. So step one is get that medical note from your doctor that outlines what your restrictions are and what the accommodations are that you require for the modified work. And then you provide that to your employer. Then your employer does actually have to accommodate you, again, as long as it's not impossible. And there's a very, very high threshold that the employer would have to meet in order to say it's impossible or that it's too expensive. Even if it costs the employer a little bit of extra money, that's expected. There's a minor inconvenience that comes with an accommodation, and that's fine. That doesn't mean that it's impossible. So in general, they do have to accommodate your modified work. And if your employer is not doing that, even though you've done what you're supposed to do as an employee, you got your doctor's note, you provided it to your employer, and they're refusing to provide modified work, then get in touch with us right away, because that's, and I see, Iona, you just sent another message, despite the doctor's note, they sent my husband home. Get in touch with us right away, or have your husband contact us right away, because that's not in compliance with the law. That's potentially discriminatory conduct there with respect to your husband and his medical condition. So his employer definitely needs to accommodate him, like I said, as long as it's possible. So he should definitely get in touch with us. Again, he can contact us by going to employmentlawyer.ca and contacting us that way, or he can email us as well at help@employmentlawyer.ca. So he should definitely get in touch with us right away, because that employer is not complying with the law. I have a question here from Razor Sharp on YouTube, who says, I work in a casino and I am federally regulated, but I was laid off almost a year ago. I don't think they are going to recall me at all. Do I have any severance entitlements? So, very good question, and very interesting with respect to your job at a casino. So in terms of the way that the law works when it comes to layoffs, layoffs aren't lawful in and of themselves. So normally, forgetting the pandemic for a second, the way that layoffs would work is that an employer would either have to have you sign something in writing, like an employment contract, that says you agree that they're allowed to lay you off. For you, because you're federally regulated, it would be in accordance with the Canada Labour Code, rather than the Employment Standards Act of Ontario or BC or whatever province you might otherwise be in. Or if they've laid you off in the past, you've gone on the layoff and then you've come back to work business as usual, then there's a precedent that's created. So if neither of those conditions exist, then a layoff is not actually lawful to begin with. So in terms of a layoff with respect to COVID or any other reason, if that's the case where your employer is laying you off and they don't actually have the right to do it because you don't fall under one of those two conditions I just mentioned, then you can actually treat that as a dismissal, as a termination, and you can pursue your severance entitlements. Now, with respect to the casino specifically, and some other workplaces, it's a little bit different if the government shut down your workplace. So if it's not the employer's choice to lay you off, in other words, if the government is forcing them to do it and they had no choice in the matter, that same layoff analysis doesn't necessarily apply because the employer is not choosing to put you on a layoff. They have no choice. The government is shutting down their workplace. So if that's the case, for the period during which the government ordered the shutdown, unfortunately, there isn't much you can do about that. But once the government has allowed certain workplaces like casinos to reopen, then there is that same layoff analysis that would apply. And if you don't want to accept that layoff, you don't have to, and you can go after your severance entitlements. With respect to you specifically, Razor Sharp, if they're not going to call you back, or you haven't accepted a layoff, you still may have entitlement to severance at this time. So even though you've been on a layoff, depending on the circumstances, there might still be a way to pursue this, especially if they don't recall you within the time they're supposed to. And the Canada Labour Code prescribes a specific period. It has been extended multiple times throughout the pandemic, but if they don't call you back by the deadline prescribed by the Canada Labour Code, if let's say you've accepted the layoff or it's a lawful layoff, then at that point you can go after your severance entitlements. So I would recommend that you get in touch with us because your specific situation is a little bit more complicated than most, specifically because you worked at a casino and you're federally regulated. So we'd want to know more about your situation before giving you, exact advice, but that would be in general the case for you. And so if it's an unlawful layoff, certainly you can pursue severance pay, and we would be happy to help you do that. So get in touch with us and we can certainly assist you with that. All right, so just gonna get to another question here. Evelyn from Facebook asks, if after July 3rd, ESA temporary layoff rules do end, what are the obligations of the employer to anyone still on temporary layoff? So this is coming up soon, actually, in about 6 weeks or 5.5 weeks time. And this is a question, Evelyn, that we've been getting from a lot of people. So if you're not familiar with what Evelyn's talking about, the ESA temporary layoffs after July 3rd, what is being referred to here is infectious disease emergency leave. So earlier on in the pandemic, the Ontario provincial government actually came out with a regulation that changed the rules for temporary layoffs under the Employment Standards Act, only under the Employment Standards Act. So there are two kind of legal systems. There's the Employment Standards Act and there's the common law, which is determined by the courts. So the common law, which is determined by the courts, hasn't been changed. But if you were allowed to be temporarily laid off under the Employment Standards Act, that's what's been changed. So there are a small group of people, of employees, who do fall under that category. If, as I explained before, you've been laid off previously, or you signed something that allows the employer to lay you off, then you fall under that category of, I'd say, a minority of people who are allowed to be temporarily laid off under the Employment Standards Act. Now, under the Employment Standards Act, there are specific rules in place with respect to how long those layoffs can be. What the provincial government did earlier on in the pandemic is they introduced a regulation called Infectious, the regulation is not called Infectious Disease Emergency Leave, but through the regulation, they created what's called Infectious Disease Emergency Leave for the purposes of the COVID-19 pandemic, and that kind of replaced the regular rules for layoffs only under the Employment Standards Act. So what that means is that rather than be laid off for what the usual timeline would be, 13 or 35 weeks, depending on the circumstances, the government changed it so that the temporary layoffs, which would otherwise be temporary layoffs, are no longer called that under the Employment Standards Act. They're actually called Infectious Disease Emergency Leave. And there's a different set of rules that apply on a temporary basis, which are set to expire on July 3rd or July 4th, Evelyn, as you mentioned in your question. So initially, this Infectious Disease Emergency Leave, this change to the rules under the Employment Standards Act, was supposed to expire last year in September. Then the government extended it to January of this year, and then they extended it again to the first few days of July of this year. Now, given what's been going on in Ontario, things are improving, the vaccinations are increasing. We do expect that the government will not extend that. And what that means is that an infectious disease emergency leave will be over during the first few days of July. So if you're in a situation where you are on a layoff and you haven't been called back to work by that date, at that point, you can pursue your termination entitlements because the rules under the Employment Standards Act, the regular rules, come back into play, and you have an opportunity at that point, if you've never been laid off before, to refuse the layoff and go after your severance. If you have been laid off before, and this layoff is lawful under the Employment Standards Act, then what happens is the rules come into place and the clock starts ticking under the Employment Standards Act. The employer can then implement a temporary layoff of either 13 or 35 weeks. So if they continue your health benefits, it's 35 weeks. If they don't, it's 13. And if you're not called back by that time, then it's a deemed termination. Now, keep in mind, this is again applying to a very, very small group of people who actually already fall under the Employment Standards Act when it comes to temporary layoffs. Most people do not. Most people are governed by the court system, by the common law, where none of this has an impact. So it's really important to keep in mind that if you are in a situation where you're on either, you're a temporary layoff or infectious disease emergency leave, whatever you want to call it, whatever your employer has called it, if you're not called back to work by that date, by July 4th, and I believe that it's actually July 5th would be the Monday. Yes, so July 5th would be the Monday, the first day of the work week. You have to get in touch with us. You have to get in touch with an employment lawyer right away, because that timing is crucial in terms of protecting your rights and being able to pursue your severance entitlements at that time. Just getting to some other questions here. I have a question from Mike on YouTube who says, I was let go due to occupational asthma diagnosis at a dealership, I assume a car dealership. They said I couldn't be accommodated. No severance. I do have a WSIB claim that has been approved. Can my employer be held accountable for their lack of, and then Mike, your question trails off there. I'm assuming lack of accommodation is probably what you were going to say. So yes, the answer is they can be held accountable. If you had asthma, I don't see why that can't be accommodated in a car dealership. I don't know, of course, what your medical note required. I don't know what your doctor put forth as required accommodations. But being familiar with asthma, I would expect that the accommodations were very manageable and feasible, and by no means impossible. And so if that's the case, and they not only refused to accommodate, but actually fired you because of your disability, that's a big problem. You should get in touch with us right away. Mike, you can email me directly. You can get my email off our website, employmentlawyer.ca. There is no reason why they shouldn't have accommodated you, and even further, terminated your employment because you couldn't work there. I mean, that's ridiculous, and that's completely unlawful conduct. So you should get in touch with us right away. And we can assess the situation for you, and I can give you further advice depending on the situation and the circumstances. But just based on the information provided, that's not right. That's not lawful. I can also personally provide you with advice on your WSIB claim as well, because I do have experience with workers' compensation and the WSIB. So certainly get in touch with us and do that sooner rather than later so that you can pursue this as soon as possible. All right, I have a few more questions coming in here. So I have a question from Mad Peddler on YouTube with respect to contingency fees and declaring legal fees to EI. So just to be clear, anything that is obtained as legal fees, if you negotiate any sort of settlement or severance pay, which would be considered income, severance pay is considered income, so that is something you declare to Service Canada, and it may impact your EI benefits. But when it comes to legal fees, those are legal fees that usually would come directly out of a settlement, sent directly to your lawyer, and that wouldn't be part of the employment income or the severance that you receive. So that part of it, if it's for legal fees, or if you get an additional amount as, let's say, a contribution towards legal fees for your case, that wouldn't be declared to Service Canada because it's not considered income. That's kind of the standard practice in most situations. Of course, that doesn't necessarily apply to every single situation, but for the vast majority of cases, that's how that would work. I have a question here coming in from Superman23 on YouTube. I have been told that I have until the end of July to either look for another position with the company or accept a demotion or accept severance due to restructure. What's a good package for 11 years of service? Interesting situation. In terms of what they're offering you, I would need to know more information. So I would need to have other information with respect to, where you work, what your position is, your age. All of these factors are how we assess your severance package. So it's not based only on length of service. Under the Employment Standards Act, which is the law that contains the minimum termination entitlements that someone would receive when they're let go without cause, it is based on length of service alone. But that's just the bare minimum, and the vast majority of people are entitled to much more than the bare minimum under the Employment Standards Act. So, for 11 years of service without any other information, I mean, you could be looking at 10 months of severance pay, just to give you an example. You could be looking at more than that. I mean, it really just depends on the other circumstances that I mentioned. So I would recommend that you actually use our free severance calculator. It's severanceCalculator.ca, because that can give you an idea of what you could receive as your severance package. I still would recommend that you get in touch with us or another employment lawyer, figure out exactly what your entitlements might be, or what your option might, your best option might be here, because it sounds like you have a few options here with respect to this particular situation, and severance is probably your best option, but you might want to talk about the other options your employer is offering you. So I'd start with the severance calculator, which just gives you an idea of what you could be entitled to receive. But definitely you'll want to talk this through with an employment lawyer and figure out what would be the best outcome for you here. I have another question here from Daniel Smith on YouTube. Daniel says, I have a question regarding someone I know. Would harassment and discrimination at the workplace leading to a worsening of a mental health condition be considered a WSIB issue or an LTD issue? So depending on the situation, it could be both. When we're talking about the workplace harassment and discrimination, which leads to the worsening of a pre-existing mental health condition, if it's completely related to the workplace, you could have a very strong WSIB claim there. In addition to that, when we're talking about it worsening your mental health condition to the point where maybe you can't work, if you've become totally disabled because of it, and quite frankly, for any reason, if you've become totally disabled and you're not able to work and you do have an LTD policy in place, then you can file a claim with your LTD provider and hopefully get access to those LTD benefits that you should be eligible to receive, as long as you meet the definition of totally disabled under your LTD policy. So depending on the circumstances, it could be that you have two claims here in different areas. But if it's a workplace injury, which harassment and discrimination that lead to mental health issues in the workplace, that does constitute a workplace injury now under the WSIB's laws and rules. Certainly you could go that way, and you also could potentially have an LTD issue there. The one thing to keep in mind is that you wouldn't be able to receive double the benefits from both. So if you're receiving LTD benefits or WSIB, to a certain respect, it's one or the other. So if, let's say, you're getting WSIB first and then you get LTD, you may have to offset your WSIB with your LTD payments or vice versa. So you're not going to be able to get the full benefits of both at the same time. That's just the way that the insurance schemes work for both of those entities, LTD providers and the WSIB, because at the end of the day, the WSIB is an insurer as well. They're just funded provincially. So hopefully that answers your question, Daniel. But if you wanted to talk more specifically about your friend or your acquaintance's situation and get more information, you can contact us directly at employmentlawyer.ca, and we'll be able to assist you with respect to those types of claims a little bit more in detail. All right, I know there were a couple questions here that we missed. We're just getting to the end of our time here, so we will end now. But like I said at the beginning of this session, if we didn't get to your question, please contact us offline. We'll be happy to help you in any way we can. You can contact us by going to employmentlawyer.ca. You can call us at the phone number that's on the screen right now. You can email us at help@employmentlawyer.ca. Whichever method of communication works best for you, definitely get in touch with us and we can help you that way. So I hope that everyone has a wonderful weekend. I'm signing off on at least what's in Ontario, a beautiful Friday afternoon before a long weekend. I hope that everyone has a wonderful weekend, and I will see you in the next question and answer session.